Today we'll be talking about Pennsylvania's new mental health law called Gabby's Law, or officially Act 65 of 2020. We've all heard or had problems when it comes to getting children over the age of 14 into treatment because of misconceptions about Act 147. This new law clearly puts an end to any of those questions that may arise about who can consent and whose consent matters more. The slides containing the exact legal wording, the slides that I'm sharing contain exact legal wording included in the law. So it's hard to make that exciting, but it's important that we understand specifically what's said so we can help the families we work with so there's one less barrier to treatment. So April Dugas's daughter, Gabby, developed a severe eating disorder and became suicidal after experiencing a severe trauma in high school. Ms. Dugas was denied the right to consent for her daughter's mental health treatment, though it was clear that she could benefit from it because she was over the age of 18 and refused. After her daughter's death, Ms. Dugas approached her local representative, Jason Ortete, to ask for a solution. 6 very long years later, we're pleased that Act 65 of 2020 provides us with the opportunity to correct those previous challenges. We are so very grateful to Gabby's mother, April, for tirelessly fighting to correct the misconceptions, and really our legislators for helping draft such a clear and easy to understand law. So let's get into it. Outpatient treatment. The following shall apply to consent for outpatient treatment. A minor age 14 years or older, the parent's consent is not necessary. A parent or legal guardian of a minor less than 18 years old may consent to voluntary outpatient mental health exam or treatment on behalf of the minor, and the minor's consent shall not be necessary. A minor or another parent or legal guardian may not abrogate consent provided by a parent or legal guardian on the minor's behalf to voluntary inpatient or outpatient mental health treatment, nor may a parent or legal guardian abrogate consent given by the minor on his or her own behalf. So abrogate is one of those legal words that we don't use in our daily conversation, so let's take a minute to go over it. It really means repeal, to do away with. So a school district may not abrogate the mandate to begin transition planning at age 14. And some synonyms are repudiate, revoke, repeal, overturn, overrule. So let's do a scenario. If you're here joining us today, I'm going to ask that you kind of think about this. And you can chat in your answer if you'd like. A therapist has been working with 14-year-old Abby concerning her eating disorder. They've been working together for 6 weeks. It's the longest Abby has stayed with any therapist. Abby's on the verge of a breakthrough and doesn't want to go any further because she's uncomfortable. Abby wants to fire her therapist. The therapist feels that Abby is exhibiting avoidance of the issue at hand, and the therapist feels that if they can continue working together, a breakthrough will happen. Abby has fired her last 3 therapists. Abby's parents want her to continue with this therapist. So let's take a minute and think about it yourself. Do you believe that Abby has the right to fire her therapist? Some points to consider. Perhaps Abby initially gave consent, and we don't know, but what we do know is that the parents are providing consent right now. So it really comes down to the question, can Abby override her parents' consent? The answer to the question is no, she cannot. Remember that one party cannot abrogate another's consent. So let's try this again, looking at it in a reverse. 17-year-old Alyssa, with the help of her school guidance counselor, and shout out to her guidance counselor for helping, great. She has sought outpatient therapy due to her feelings of anxiety. Her father's aggressive behavior and verbal altercations with her mother make it impossible to even think when she's at home. After the first month of outpatient treatment, Dad finds out. Dad's furious and demands that Alyssa terminate treatment. The question is, does Alyssa have to stop outpatient therapy? The answer is no. Alyssa does not have to stop outpatient treatment. Again, no one may override another's consent. Let's talk about inpatient treatment. A minor's parent or legal guardian may consent to voluntary inpatient treatment on behalf of a minor less than 18 years of age on the recommendation of a physician who has examined the minor. A minor 14 years or older may consent to voluntary inpatient mental health treatment on his or her own behalf. And again, neither party may abrogate consent provided by the other party. So let's take a minute to talk about our use of the word voluntary. People often get confused because a child may not voluntarily be willing to go into treatment, either outpatient or inpatient. So our use of voluntary is really just that this is not a 302 situation. We also get the question frequently when we do this presentation, if inpatient treatment will show up on state police records. In our case, as a voluntary admission, which means the treatment is not being mandated by the court or judge, the treatment will not show up on a state police screening. So again, involuntary commitment, a 302, is really in that emergency situation where a person is a danger to themselves or others due to mental illness, and that's usually court mandated or mandated by law enforcement. That is not what we're talking about when we talk about voluntary treatment. So how consent works for inpatient treatment. A parent or legal guardian who provided consent to inpatient treatment may revoke that consent. They can change their mind. Now, that inpatient treatment will continue if the minor now provides consent. And again, the reverse. A minor who has provided consent may revoke that consent. Treatment will continue if the parent or legal guardian has provided consent. So maybe everybody's in agreement that the child goes into a residential treatment facility or drug and alcohol treatment. And once they get there, one party changes their mind. As long as there is still consent by the other party, they can stay. And of course, if you change your mind and nobody else gives consent, then, it's done, you can go home. So let's talk about inpatient treatment and requests for modification or withdrawal. Of course, there's still protection for a child should they really feel that inpatient treatment is not appropriate. And this is great because we want our children to be aware of their rights so they're informed and can exercise them. So at the time of admission and inpatient treatment at an inpatient treatment facility, a representative from that agency will talk with the minor and explain the nature of the program. A statement of the minor's rights to object will be explained along with they'll be given a written copy. If the minor wants to exercise this right, the director of the facility will provide the minor with the notice of the request for modification or withdrawal from treatment. And a representative from the agency will file a signed petition with the court. After filed, the court will promptly appoint an attorney for the minor, and a hearing will be scheduled to be held within 72 hours following the filing of the petition. So the big question, where's the minor during these proceedings? The minor remains in the inpatient facility until a judge or mental health review officer determines if the mental health treatment is in the best interest of the minor or not. So how long will this go on? A minor ordered to undergo treatment will remain and receive inpatient treatment for up to 20 days. A patient will be discharged when the attending physician determines that the minor no longer needs treatment, or at the end of the 20 days, whichever comes first. If at the end of the 20 days, the attending physician determines continued inpatient treatment will be necessary, the minor doesn't consent, the court shall conduct a review, and that will determine whether we're going to release the minor, make a subsequent order for inpatient treatment for a period not to exceed 60 days. So let's say a child exercises their rights and says they don't want to be in treatment. It then goes in front of a judge. The judge makes the determination the child must stay in treatment for 20 days. At the end of the 20 days, there's 4 things that can happen. The child can be released by the attending doctor. The child's well enough to go home. The doctor believes treatment should continue and the child agrees to stay. Fantastic. The doctor believes treatment should continue and the child wants to go home. So they go back to the judge. But this time, if the judge agrees, the child stays for 60 days. Now, this cycle continues until the doctor says the child is better and can go home. The child agrees to stay, or that 4th option is where the parents withdraw their consent and decide to take their child home. And of course, the child doesn't at that point provide their consent. So let's do another scenario. This time, 16-year-old Jacob is in need of a residential treatment facility due to his sexually problematic behavior against his 10-year-old sister. Jacob does not want to go to a residential treatment program and has agreed to remain in outpatient therapy. After speaking with Jacob's therapist, Mom agrees that a higher level of care is needed in order to for Jacob to make the progress that's needed. While searching for a proper RTF, Mom is told over and over that because Jacob is 16 years old, he will have to agree voluntarily to going into an RTF. Does Mom have the right to sign for a voluntary placement for Jacob? So yes, the answer, she does. And once there, of course, Jacob can exercise his right to complete a request for modification or withdrawal from treatment. So let's talk about what happens when there's a disagreement on the inpatient treatment of a child. Nothing in the subsequent section or in the subsection shall prevent a non-consenting parent who has legal custody rights to the minor to object to the consent given by the parent to inpatient treatment by filing a petition in the Court of Common Pleas in the county where the child resides. The court must hold a hearing within 72 hours of the petition. So when there's a disagreement on inpatient treatment, the child remains in treatment if they're already there, and the non-consenting parent has the obligation to request a hearing. Both parties do not have to agree in order for treatment to start. And remember, for both inpatient and outpatient treatment, no one may abrogate the other's consent to treatment. This applies to parents as well. Act 65 of 2020 does provide this extra protection for inpatient treatment of having a hearing in front of a court officer. Because it's inpatient treatment, it's a little bit more intensive, and we certainly think that that's a good thing. So let's talk about release of medical records. A minor may consent to the release of their records and the information to the minor's current mental health treatment provider. Parents or the legal guardians may consent to minors' medical records, to the release of a minor's medical records and information, if such release would not be detrimental to the minor. And information released will be from one professional to another professional. I think that sometimes when parents ask to see their child's medical records, they think it will tell them what's going on with the child, like what they say in treatment. And we at the Parent Alliance can help parents understand that that's not information they'll be able to see, because that's really not how therapy works. So if you're a provider and you're working with a family who has some questions or concerns, we'd invite you to reach out to us, and we can all work together. We can work with the family, support the parents for the betterment of the child. So a parent or legal guardian who's providing consent for a minor to receive mental health treatment shall have the right to information necessary for providing consent to the minor's mental health treatment, including symptoms, conditions to be treated, medications, and other treatments to be provided, the risks and benefits, and the expected results. So again, Act 65 of 2020 allows a minor age 14 and older the right to consent to mental health treatment. Parents, as always, have the right to consent to mental health treatment for their children until they turn 18. No party may abrogate the consent of another. Non-consenting parent of the minor may object to inpatient treatment through the court. And release of medical records and information can be requested by either parent or legal guardian or by the minor. And basic information can be released to the parent or legal guardian. We've created a really nice one-page document in both English and Spanish that breaks down the new law that you can share with your colleagues or the families that you work with.
It's a 16 buff in the dark.